Start para. This appeal is directed against the judgment and order dated July 11, 1961 of a division bench of the Bombay High Court, Nagpur bench, dismissed appellant's application under Article 226 of the Constitution, read with Section 491 of the Code of Criminal Procedure, wherein he had prayed for a writ of corpus against the state of Maharashtra and the district magistrate of Nagpur, directing them to produce the petitioner in and to set him at liberty. This application was heard by us on January 8 and 9, 1962, and after hearing Sri A.S. Bobde for the appellant and the learned Attorney General for the state of Maharashtra, we directed that the appellant be released forthwith and that the reasons for our judgment will follow later. We now proceed to set out our reasons for the order passed on that date. Para. He also directed that the appellant should be detained in the district prison Thane and that for the purpose of the Bombay Conditions of Detention Order 1951 be treated as a Class 2 prisoner. The grounds of detention were served the same day. The substance of the grounds is that since his release from previous detention in October 1960, he had been instigating persons at Nagpur to defy and disobey reasonable directions and lawful orders issued by competent authorities from time to time, prohibiting and regulating processions and assemblies at Nagpur, that by use of highly provocative words, expressions and slogans in meetings and processions in Nagpur, in which he took a prominent part, he had instigated persons on several occasions at Nagpur to indulge in acts of violence and mischief and to create disturbance in the city of Nagpur, and that he had been acting since October 1960 in a manner prejudicial to the maintenance of public order in that city, and then follow notable particulars of his activities running into 5 closely typed pages and contained in many paragraphs in his petition to the High Court. The petitioner raised a number of grounds of attack against the legality of the order of his detention, and most of those grounds have been reiterated in this court. We do not think it necessary to go into all the points raised on behalf of the appellant by the learned counsel. In our opinion, it is enough to say that we are satisfied that in the circumstances of this case, the provisions of Article 22 (5) of the Constitution have not been fully complied with, and that therefore the appellant had not the full opportunity provided or contemplated by that article of making his representation against the order of detention. Para. In this connection, it is necessary to state the following facts. The appellant wrote a letter to the district magistrate of Nagpur on April 19, 1996 to the effect that he had been served with an order of detention dated April 10, 1961, and that the order and grounds of detention being in English, he was unable to understand them and therefore asked for a Hindi version of the same so that he may be able to follow and understand the charges leveled against him and take necessary steps for his release from jail. He raised some other questions also in that letter, but it is not necessary to refer to them here. To that letter, the district magistrate replied by his letter dated April 23, 1961, the second paragraph of which, in the following terms, set out his views of the matter. The order of detention and the grounds of detention already communicated to you are given in English, which is the official language in this district. It is not possible to supply any translation of the same for it legally necessary under the Preventive Detention Act 1950. The order and the grounds of detention served on you were fully explained to you by the police officer in the presence of the DSP, Nagpur City, Para. The High Court dealing with this contention on behalf of the detainee came to the conclusion that under the Constitution, English still continued to be the official language of the state of Maharashtra, and that service of the order in English upon the detainee was sufficient compliance with the requirements of Clause 5 of Article 22 of the Constitution. It also held that the failure of the district magistrate to supply the grounds in Hindi did not have the effect of preventing him from making his representation to the authorities. Furthermore, the High Court pointed out that the district magistrate had stated in his letter that the grounds were explained to the appellant in Hindi by the police officer at the time the order and the grounds were served upon him. In the view of the High Court, therefore, the explanation or translation of the grounds by the police officer at the time he served those on the appellant should be deemed to be enough to enable him to make an effective representation against his detention. Mr. Bobde, for the appellant, has vehemently argued that the requirements of the Constitution had not been complied with in as much as Clause 5 of Article 22 of the Constitution required that the grounds on which the order of detention had been based had to be communicated to the detained person. His argument further was that communication of the grounds was not equivalent to serving the grounds in English upon a person who was not conversant with the English language, and that oral translation by the police officer said to have been made to the detainee was not sufficient compliance with the requirements of the constitutional provisions, which must be fully satisfied in order that the detainee may be in a position to make an effective representation against the order of detention. He also contended that we do not know in what terms the police officer translated the lengthy document or whether his translation was correct. Stop.